Welcome to today's session, everyone, on federal year-end spending, opportunities and challenges, brought to you by Graduate School USA. If we haven't had a chance to meet in another one of these, my name's Brian Sims. I'm the Senior Director of Product here at Graduate School USA, who's been a trusted training partner to federal government professionals for more than 100 years. Sessions like this one are just one of the many ways we strive to serve our clients and friends in the federal community. Whether you're here to sharpen your skills or to explore new ideas, we're eager and ready to help you with your training needs. So a few housekeeping items before we get started today. This session will be recorded and it will be made available to you after the event today. We will not be providing PowerPoint copies of the PowerPoint slides. And since we do expect so many folks with us here today, we're going to be keeping microphones muted because, as I mentioned, we do have a lot of great information to get through. Lastly, we don't expect to have time at the end of today's session for live questions, but do feel free to use the chat or the QA area that you can see toward the tops of your Teams window, and we'll try to address those at the end of the session if we can. So with those few housekeeping items out of the way, it's my pleasure to welcome today's speaker, Stephen Potts, a seasoned management consultant, trainer, and former federal executive with more than 30 years of experience advising government and industry leaders on budgeting, fiscal accountability, and performance improvement. Mr. Potts has held senior positions across the Department of Defense, Department of Energy, and in the private sector, and is a recognized expert in federal appropriations law and acquisition. He brings a deep insight into the opportunities and risks that come with year-end spending, and we're thrilled to have him share his expertise with us today. And so with that, I will pass the microphone over to you, Steve.
Thank you very much, Brian. I'm delighted to be here with you, our career professionals, our in the government, our contractors who join us for this, and just interested parties who want to know more about how to do year-end spending and what not to do at year-end. As Brian said, I'm Steve Potts. There's a little bit about me on a slide or two forward here. What I want to do, though, is I want to just thank the Graduate School for this opportunity to be here and to present it. And I want to mention the slides are actually my property. The Graduate School is my sponsor. These are not work for hire. So what you can do with these is you're welcome to take screenshots of them. And you're welcome to use those for your own purpose of training, but please don't redistribute them because we got competitors out there, the Graduate School does, and I do, and they love to pirate our materials. So please don't redistribute them. Use them for your own purposes, and you're welcome to do so. And I also want to reemphasize the Graduate School is the oldest and the most prolific provider of postgraduate training to the federal government. That means something. We do about 1,200 courses total that we have available for you, and we do them in person and virtual. And some of my own experience with the Graduate School is the ability to travel all over the world to deliver these courses. And thank you to the Graduate School for the experience in doing this. So far in my own career, including graduate schools work, I've managed to work in 47 countries around the world. It's been an interesting, amazing experience to deliver quality material to professionals all over the world like yourselves. And the question is, why do we do this today? Why do we invite you to come to this course for free? Well, we do it because, in the famous words of the Mickey Mouse Club long ago, because we like you. But we also appreciate you, and we don't want you to have some of the problems some of us have experienced in our own careers, including investigating a number of and being investigated by a few federal investigations. We've got folks who've been investigated. We've got folks who've been involved in investigations from the other side. We just don't want you to have the same problems that the parties involved in those had when you're on the end of the investigation. They're unpleasant. The only thing I can liken them to is there's a test when you reach the age of 55. They tell you to take this special test involving a laxative, a sedative, and a long hose. And all I can say is you feel very clean afterwards. Same thing with one of these investigations. You don't want it. So what we want you to do is stay on the right side of the law. We want you to understand what we can and cannot do, and we want you to stay within the bounds. And on this particular time today, where we are in history, I know that many of you are concerned about the future. I know that many of you are nervous about the future. I know that many of you are seeing massive changes going on within the government. I want to suggest hold steady. Things level out over time. And the law will play out. And the reason I'm saying this is because we're going to touch on some things which are hot topics of interest to the press, to Congress, to the administration right now, and to lots of other people as well. And we're going to stay out of politics. We're not going to pat anyone on the back or criticize anyone. We're going to tell you how the law is supposed to work according to all the decisions that have been made before. And we'll just see how everything that's going on plays out. What we don't want you to do is step over the bounds of the law and get yourself into a situation where you potentially get investigated, potentially get imprisoned. I've been involved in investigations in which people have been imprisoned for their misuse of federal money. So we don't want that for you. We want you to stay on the right side and to be correct in what you do and to stay safe. It's a safety valve and a prophylactic, so to speak, for each of you who deal with federal money. And anyone who does do any of these projects, programs, activities, make policy, develop financial programs, analyze, budget officers especially, contracting officers, purchase card holders especially, voucher examiners, dispersing officers, auditors, we all have to know how the money works. And this is how the money works at year end. So be sure if you do have questions, drop them in the chat. I'll do everything I can to take time at the end of our discussion to answer your questions. And as we said, we're staying out of politics. We're just talking about the facts as they are. And we see how the various disagreements play out over time. And I think this will also help you know more about how these disagreements are likely to play out over time as you listen to what we have to say in this course. It's a public service to our friends and colleagues, but you need to know, those of you who deal with money already do probably, those of you who are new or haven't yet dealt with federal money probably don't realize the consequences and the challenges at year end. So we want you to stay safe because your risk is the highest at year end, but so is your opportunity, because at year end, money becomes available that wasn't available before quite often. And if we know how to use it properly, we can use it properly and get more things done for the public, which is really what we're all about in our government. So we want you also to increase your professional knowledge and to limit your personal liability while getting the best possible job done for your agency. Let me just mention, if you don't know that if you're a supervisor, a manager, that you can ask your agency for compensation reimbursement for 50% of your professional liability insurance each year, and your agency is required by law to pay it if you qualify, then you should take appropriations law, because that's where you learn all about. That's what the law says, and many people, my daughter included, took the precaution of doing that, and most of those people have been glad that they did later on. In some organizations, it's not unusual to see 3, 4, and 5 people under lawsuits at any one particular time. So know what your limits are, know what your professional thresholds are, and also know that there's a way to protect yourself somewhat if you're a manager in the federal government, and there are lots of managers, and learn about it and be careful out there. So year-end spending, what we do with our money during that last critical month and the last few crucial minutes of each fiscal year has been problematic a long time. Far too many feds get themselves in trouble and their agencies into trouble with mistakes right at the end of the year. And the primary root cause in my own experience is either one of two. It is either lack of knowledge or pure absolute arrogance, one of the two. And I don't think there are that many truly arrogant people in the government. There are a few. I don't think there are that many of them. So most of the primary root causes are lack of knowledge, but it really doesn't matter that you lack the knowledge, because when you take a job in the federal government, the expectation is that you know all the laws, rules, and regulations that apply to you in that job the moment you take the job. And if you fail to make sure you do, that can be considered negligence. And negligence is important because if we determine that you owe us money, there are only two ways to get out of it. Well, one way to get out of it, and you have to prove two things. You were operating in the line of duty and you were not negligent. So be sure you know the rules. We're going to cover the primary laws on year-end spending. We're also going to talk about some specific limitations all officials must consider during the year as well as at year-end. We're going to talk about the key issues to consider with year-end spending and what you can do at year-end. We're only 74 days by my count away from the end of the year right now. And as we get closer and closer and closer, the tension mounts. But you should know that there is a new approach to an old interagency problem. The interagency problem is the Economy Act. Because under the Economy Act, which dates back to the 20s and 30s, When you do an interagency agreement, just like you at your own organization, that other agency's people must stop work on that interagency agreement at year end. That's very disruptive sometimes. But if you know what the new rules are, they can keep working even though you might not be able to if you do it right. And we're going to talk about how to do it right in this class. We're also going to give you some cautions to observe and the need for proper documentation, especially at year end. So I'm going to say it once and I'll repeat it at the end. Documentation can save your bacon or it will cook it, one of the two. Lack of documentation quite often cooks people's bacon because auditors do not accept ex post facto documentation. They want it done contemporaneously. So be sure you keep documentation for what you're doing at year end. Put it where you can find it when the auditors arrive if you need it. Now, everything that we've done in here is taken directly from law, rule, or regulation, primarily from the United States Code, the Code of Federal Regulation, CFR, and for principles of federal appropriations law. And we've got the references by chapter and page number for the Red Book references, principles of federal appropriation law, along with each of our citations here. By the way, in this particular document, they are accurate. In the Red Book, they're inaccurate because they're out of date. It's amazing to me that we've had the current Comptroller General of the United States for 15 years, and his term is up in December, and they still haven't completed the update to the Red Book, which had been started well before this one became Comptroller General. Kind of amazing to me, because GO usually sets the standard, but I don't know why it's still out of date. And you have to know, part of it, you have to know that it's been rewritten in chapters 1, 2, 3, and 4. Those are condensed down into chapters 1, 2, and 3. Those are in the 4th edition. In the 5th edition, everything from there on, beyond what we refer to as the purpose rules, is not rewritten. And there's an update book that goes along with it. So when you deal with those citations in those chapters 5 and beyond, what you need to do is you need to be sure that you take a look at the update book at the same time and check to see if the page you're working on has had changes made to it by the update book. A little complicated, but not that bad once you examine it and determine what they're talking about. Okay, so all PFAL, Principles of Federal Appropriations Law references by chapter and page number. So our problem at year end is like being between the falling rock and the hard place. The falling rock is the Impoundment Control Act, which requires everyone, even the president, to spend it all. This year's money should be all obligated this year before the end of the year. At the same time, the very fearsome Anti-Deficiency Act says if we spend even $1 too much, we could face penalties as high as being fired, 2 years in federal prison, and a $5,000 fine. And we pay the losses back to the government personally. So what are you going to do? It's a tough place to be. Well, be very careful and follow the rules, is the rule. So what we do actually, I want to mention, is that we come very close, but not quite. For me, having been a contracting officer, having been a program official, the two programs that I've been talked the most about are the two that I was involved in creating. The alcohol fuels program, which in 10 years put 10% more fuel supply for the American automobile and 10% ethanol in mini-liter gas tanks, and the Advanced Space Technology program, which sponsored the first 2 commercial space launches, including one company you probably never heard of called Orbital Sciences, now merged in another one, and one company which is currently in the news called SpaceX. Long before Elon Musk even knew it existed. And those 2 launches led to what we now see where commercial space is doing lots for us. So my point to you is we've gotten to see this, many of us have in this organization, and we want you to not make the same mistakes others have. How do we end up in these crises? Obligations made too late. I end up teaching a lot of auditors in my classes, and I teach auditing classes as well. Having been with Pricewaterhouse long ago, and done some auditing, particularly internal auditing in the federal government. And what I tell auditors is if you want to find the big ones, you wait till year end, start a year after midnight, not a year, but an hour after midnight, work backwards looking for large numbers. Anytime you see a large number, review that contract and see if there's not a violation of law in it. Because what happens is people think they can sneak them by at the last minute. They do. And a lot of them get caught. You want to see one? Look at 2006 and 2008, the same violation cited twice, on the GAO website for USAID, and you'll see there where they violated the law big time, $7.5 million worth, because they did things that were illegal to do that anyone who had bothered to take a single course in appropriation law would have known better. Oh, by the way, they fired the chief financial officer, they fired the management administrator, they fired the attorney, the assistant general counsel, who advised on it, and the contracting officer, as I understand it, I've heard, but I haven't tested it, got sued for $7.5 million by the vendor for the failures. Oh, they recommended them all for prosecution. They did. So what's the point here? That's the big downside we're dealing with. We don't want you to have to deal with the downside. Just do it right. So we also have purchase cards used improperly, or we order too much at the end of the year, more than the bona fide needs of the current year, or the users of purchase cards fail to stop in time or within the fiscal limits, and they take you right over the edge with them. As for me, what I do is I take them all up and lock them up in a safe 2 weeks before the end of the fiscal year and stop them to make sure they can't be used. Why? Too much danger. I don't want to have to face an investigation because someone who works for me used a purchase card improperly on the money I'm responsible for. So we also have illegal purchases. People try to sneak things by. Not a lot, but it does happen. And we also fail the necessary expense test when Congress tells you to buy a specific thing. The necessary expenses of getting that thing to the site of installation, setup, testing, training, and the first year's warranty, if there is one, is included in the cost of the thing. You can't then buy the thing and leave it sitting on the vendor's loading dock and then use other money to go get it, if we've been told to buy that specific thing and give them the money for it. And I've seen that happen. In fact, was involved in that one when we bought the very first supercomputer in the federal government, Cray supercomputer serial number 001. That very thing happened with that one. And we had to stop it and fix it. So lack of documentation. That's important because there's a fine line between what is legal and illegal sometimes at the end of the year. And the key to it is to show that you did your due diligence. And the only challenge, if you did it correctly, the auditor can make is that a reasonable person would not have done it that way. It's called a reasonable person test. And if any other reasonable person involved in that believes it would be okay to do it that way, auditor loses. Okay, so that's the issue. Be careful, document, do it right. Let's talk about the legal framework. There are two key legal principles, and each of them come right out of our Constitution. They have not been changed since it was written. And it says that Congress has the power to make all laws which shall be necessary and proper for carrying to execution the foregoing powers, their powers, and all other powers. That's all other powers of the federal government, vested by this Constitution in the government of the United States or in any department or officer thereof. They make all the law for the entire government, period. Now, they can't possibly tell us everything to do all the time. So what we do in our agencies, we write regulations based on those laws. And so long as the regulations are under our authority and are constructed properly, there are rules about how we do it, then we have to follow the regulations as well. So beyond what we talk about here, look at your own agency's regulations. I'll show you a couple of places it's really important to do that. And then what I call the prime directive from the Constitution itself, as far as money is concerned, no money shall be drawn from the treasury, but in consequence of appropriation made by law. If you don't have it, don't try to spend it. And it can only come to you through a form of appropriation if you're going to spend it for the purposes of the federal government. Oh, some of you may say, I've got non-appropriated funds. No, you don't. 99% of the people who think they have non-appropriated funds are wrong. A few are right. If you're in DOD and you're working in the military exchange system, Army, Navy, Air Force, and Marine Corps, Army, Air Force, Navy, and Marine Corps exchanges, those are non-appropriated funds. The commissaries are not. They're appropriated funds. They're working capital funds. And all the rest of the work you do is done with appropriated funds, unless you're receiving gifts, but the ability to keep the gift and use the gift must come to you through an appropriation. Otherwise, you can't use the gift money. So it's all appropriated funds. So what we're talking about applies to everything you're going to do with federal money. So only Congress makes appropriations. We just said that. Congress has the power to limit them as it sees fit. And the Constitution leaves it to Congress to decide the details on these limitations, and they do through that through several legal devices. They write the law, but they also give to one individual the power to make decisions about the proper use of money under the law, interpret the law, on behalf of the executive branch. but he doesn't work for the executive branch. He works for Congress. He's called the Comptroller General of the United States. They've all been he's so far. They have a 15-year term. If they serve the full term, they retire at full pay and full benefits for life. That's $208,000 a year for life and full benefits. So most of them stick around. The last one quit before the one we have now over protest because he said, what you're doing with money is unsustainable. And they've been saying that, and we've been saying it, including the current Secretary of the Treasury, the previous Secretary of the Treasury, and the one before that, and the previous and current Chairman of the Federal Reserve Board. And the previous Chairman of the Federal Reserve Board was also later the previous Secretary of the Treasury. They ought to know what they're talking about. And Gio's been saying the same thing now for over 15 years. We're going to break it. And that's what you're experiencing. It's shaking right now. We have $47 trillion in debt, or in liabilities, excuse me, not just debt, liabilities, and we've only got $6 trillion in assets. When a banker looks at that, they say you're way past bankrupt. And it's the bankers who lend us the money to keep the government going. So Congress has piled up debt to the point at which we're doing something about it. You can see it happening right now in Congress and in this particular administration. No comment about success. I just pray and hope that they're successful over time, because we do have a serious problem we have to deal with financially. In the meantime, you and I have to do our job. So the agency may, within scope of law, further limit itself and its agents by regulation, as I've already said. I'll show you a place where it does in particular. So Congress limits us by the permanent statutes that we have that create your agency. They also limit us by permanent statutes on money, most found in Title 31 of the United States Code. Some are also found in Titles 40 and 41 and scattered around a few other places. They also limit it in your agencies enabling and authorizing legislation, and each of your parent agencies has a law which creates that agency, and if you look at it, it'll give you some conditions on the use of your money. That plus the permanent statutes, plus the annual appropriations acts, plus changes to the permanent statutes over time with authorizing acts, give us our body of limitations on money legally in the law. They also stick riders on other legislation from time to time. One of the biggest furors we've seen in my own personal history was the Iran-Contra case, and it was caused by a rider on a piece of legislation that says don't use any money, whereas we had another piece of legislation that said use $200 million to do this. And the question is, which one do you follow? And unfortunately, people didn't pay attention closely to the last one and got themselves in lots of trouble. Also, the decision of the Comptroller General, who works for, as I said, Congress, govern the use of money by the executive branch. It's very clear in their legislation. They have the authority to do it, and we have to listen to them and pay heed. That's why they do the Red Book, Principles of Federal Appropriation Law. We also have government-wide regulations, such as the Federal Acquisition Regulations or the Super Circular, which is the Code of Federal Regulations, Title II, Section 200, which deals with grants. We have to follow those rules. And then we can have agency-specific regulations, and as long as they're within the law, we have to follow them also. So I say to you, beyond what we do here, look also at your agency-specific regulations beyond this particular discussion today and see what they say. So we're going to focus here on the key laws on money in all agencies, absent some statutory exceptions that might exist in some agencies. We'll talk about a few of those at the very end of our discussion, but we're primarily coming from Title 31 and Title 41 United States Code in our discussion here, and some key decisions of the Comp Gen that bind all federal agencies, absent having a separate statutory exception. We're also going to look at relatively recent laws and one Comptroller General decision that help us with our scope at year end, particularly in dealing with interagency agreements. And then there are a limited few specific agencies laws that are worth noting along the way. We'll just mention those at the end. We're not going to focus on your individual agencies exceptions, but if your agency needs further training on specific limitations exceptions, the graduate school stands ready to help. That's what we do, and we can tailor our classes to your agency specific needs if you need them. So the Impoundment Control Act, in the news right now, a lot. Congress requires the president and you to spend all the money it appropriates for a particular year. In that year, spend in this case means obligate. You don't have to pay it out, but you do have to obligate it. Under the Impoundment Control Act of '74, an impoundment is an action or an inaction by an officer employed in the United States that delays or precludes the obligation or expenditure of budget authority provided by Congress. It's a 2 U.S. code. The act applies to salaries and expenses as well as program appropriations. That's from Principle of Federal Appropriations Law, page 1-32 in the new edition, fourth edition. So what does it do? It prohibits withholding or delaying the obligation or expenditure of budget authority, whether by establishing reserves or otherwise, provided for projects or activities, or any other type of executive action or inaction which effectively precludes the obligation or expenditure of budget authority, including authority to obligate by contract in advance of appropriations as specifically authorized by law. So basically, we are supposed to be following this closely, but there are some flexibilities in it, slight flexibilities that we need to mention. So let me back up for a second. The two flexibilities, because this is hot in the news right now, is the president has the authority to defer spending for up to 90 days at will. But he can't do it for longer than that, and he's got to inform Congress that he's doing it. And I use he for the president advisedly because they've all been he so far. So the president is in fact allowed to preclude spending temporarily for 90 days. He can then unpreclude, and my belief is that he could preclude again for 90 more days. But what he can't do is preclude so you can't possibly spend it during that year. We've had a case like that. George W. Bush, president, actually had a case like that during the Katrina disaster, in which he ended up moving money from lots of other agencies to three: Navy, Coast Guard, and FEMA. And they didn't use it all. He didn't get it back to the other agencies in time. So the Comptroller General said, that's a violation of the Impoundment Control Act, and you violated it 15 times. So far, to my knowledge, this Comptroller General has only said impoundment control violation twice under the current circumstances. And we'll see how those play out in the court, because it's the courts who will ultimately decide how those come out, not the president, nor the Comptroller General, nor Congress immediately. It'll have to go to court to be decided, because it's a very muddy issue right now. On the other hand, the president can also ask Congress through a special message to Congress to rescind money. And when he does that, he's got 45 days from the date he sends the letter to Congress to when he must release the funds if Congress does not rescind the money. Now, you saw some rescinded very recently, last night or the night before, I guess the night before last. So Congress can rescind it at will. They can take all the money back or none of it at will, but it requires Congress to rescind it. And if Congress objects together, they'd have to do that through a joint resolution of Congress. Actually, a concurrent resolution of Congress it would have to be, because the president would not sign the joint resolution. If they object, then he has to free the money up for spending, and they have not objected. Therefore, you're seeing the rescission time play out right now. So that's what's going on, and we'll just have to see how it plays out. Don't get yourself in the middle of this. It's a big issue, but you need to know how it works, because you don't want to be in it yourself because of your inaction at the end of the fiscal. You want to be doing your job the best you can. Or any other type of executive action or inaction by anyone in the executive branch, which effectively precludes the obligation of expenditure of budget authority, including authority to obligate by contract in advance of appropriations specifically authorized by law. So that's to protect, or to make sure you know you don't want to be personally responsible for taking an action or inaction, because you'll be the one who is being in front of a court at some point in time if you're wrong. Okay, so our objective then as federal employees is to use all the money as close as we can to zero, but not quite. Leave ourselves a little buffer. Congress isn't going to argue about it 1%. They're not. They know that we can't be that precise because our accounting systems are good, but they're not that good. And they're fast, but they're not that fast. So what they will do is allow us a little leeway there without objection, but don't make it a large amount. So that then our objective becomes spend the money down as far as we can, obligated, get it all obligated. You have to get it paid out, you have to get it obligated. So the use of federal money, budget authority is generally limited in three ways by law. The purpose of what we buy with that money limits it. The time that we buy the money, that we use the money, and the time of obligation, and the time to pay the bill. And the time of obligation is whatever it says in the Appropriations Act. And the time to pay the bill is always 5 years after that, except for no year money. No year money is time unlimited until Congress takes it back or you spend it all. So we're going to put no year money aside and not talk about it in this class. It's greatly flexible money, but we're getting less and less of it every year because people tend to abuse it. And then we also limit by amount, which is the limit of how much we have to use. So today's discussion is going to presume you've got sufficient amount to make the purchase you're contemplating year end. If you don't, just stop right there, don't do it, or you're over the cliff with the Anti-Deficiency Act. Just stop right there if you don't have sufficient money. So here's what the primary time limitation is. Appropriations made for a definite period of time may be used only for payment of expenses properly incurred during the period of availability or to complete contracts properly made within that period of availability. That's GO paraphrasing 31 U.S. Code 1502A. It's also called the bona fide needs statute. And once again, it does not apply to know your funds. There's no time limitation on know your funds if you're lucky enough to have them. You might have funds that are available for a year. Well, this applies at the end of that year. You might have funds that apply for 2 years. This applies at the end of the second year. You may have funds that apply for 5 years. This applies at the end of the 5th year. Or you might have funds that apply for 10 years. This applies at the end of the 10th year. You can't do obligations beyond that point. That's the key. Now, you've also got to remember, you've got a limitation on how much you actually have. That depends upon how much OMB has apportioned to our agency, how much the CFO has allotted to your organization, parent, how much they have provided to you through some other subdivision of funds. So you've got to know, does the ADA apply to the funds I have or not? If it doesn't, it means someone up the line is acting like mom or dad and guarding for you. Need a little bit more, they can give a little bit more. You don't use it all, they'll give it to somebody else. So be careful, don't stress it too much, because if we all go in there and try to gobble it up at the end of the year and they're not watching closely, we can take us all right over the edge of the cliff by spending too much. This rule here is called the bona fide needs statute, and it doesn't apply, once again, to know your funds. It can be very simply stated as use now money only for now needs. That's me paraphrasing the bona fide needs rule, but it always works. I can only operate in the now, and so can you. I can't operate in the yesterday or last minute. I can't operate in tomorrow or next minute. I'm in the now. So check, do I have money now? Yes. Do I need this now? Yes. Satisfy the bona fide need. That's the key. Document it. So when discretionary appropriations are time limited, then the bona fide needs rule does apply. There are exceptions. Know your funds are available until expended. What does that mean? Until we have accepted the goods under the contract that we made the contract for, obligating them. Once you accept the goods, you own them, the government owns them, and we have to pay the bill. That's when funds are actually legally expended. These have no time limitations if they're know your funds, and they can be obligated at any time until Congress takes them back or we spend it all. Multi-year funds are appropriated for multiple years, and they're available for the legitimate needs of any or all of those future years. Anytime you need something that meets the purpose of the appropriation you're using, you can use that money for it until the last moment of the last year of that multi-year period. For multi-year funds, the time limitation applies only at the end of the last year availability for obligation, just to remind you. So in addition to the bona fide needs rule, most Appropriations Act have a general proviso in them that says no part of any appropriation contained in this act shall remain available for obligation beyond the current fiscal year unless specifically provided herein. And what it does is it causes the Appropriation Act itself to expressly provide for any availability beyond 1 year. So what if it doesn't say the availability in the appropriation line item? A line item is that paragraph of text that doesn't have any periods in it that says money is appropriated for this purpose within this time period and in this amount. That's what it gives you. And it's right there in the paragraph. What if it doesn't say? Then it's 1 year money. That's the rule. If it doesn't say a time period it ends, if it doesn't say September 30th, 2027 in the upcoming budget they give us, it's going to be end of year, September 30th, 2026. If they want it to be longer than that, they'll say it right in the law itself. The only exception to this would be a modification by a law enacted later in time. Congress can always come back and say that money we gave you for 1 year, now it's available for 5. They could do that. They're unlikely to, but on occasion, when we can't use it all up, they will reappropriate money, giving us more time to use it. You should know that, because sometimes if you're in a situation where policies have kept you from appropriating the money, but now the policies have changed, the laws changed the policy, we can still get Congress to make the money continue to be available by asking them to reappropriate it, but don't run past the end of its time period or you'll violate the ADA. How do you know when time runs out? Read your Appropriations Act. You're responsible for it. So when does that year end? And this is something that is not subject to debate. It's well tested and well tried. There's a last moment in time, and it's September 30th at 23:59:59. It's not midnight. Midnight is 00:00:00 October 1st. It's too late. 1 second can make all the difference in the world. But the clock stops, this clock, on local time in your time zone. And interestingly enough, we've got 24 time zones in our world. Each one is a little more than 1,000 miles across, depending on how they drew it at the time. There's some that are kind of squiggly. The Earth spins to the east at about 27,000 miles a day, roughly 1,000 miles an hour. And as as Earth spins to east, time moves to west. So with 24 time zones, time is going to run out in Hawaii 20 hours later than in Guam. It does. Even though they're pretty close together, they're only two time zones apart, as I recall. So what's going on here? Well, we're just dealing with geophysics. The Earth is spinning, time is moving, but we've got to be very careful. So this is why your agency may set an earlier fixed time to end obligations in a specific location, Eastern Standard Time. Many of them have done this. It'll say 10:30 p.m. Eastern Standard Time. Don't follow that. Don't follow this. If it doesn't say, your agency's regs don't say, follow this. And in fact, DOD and other international agencies, State Department, sometimes USAID, actually move money completely around the world in the last 6 hours of a fiscal year. They actually do. I've been there, done it, and watched it happen. Guam runs out of money first. They're the first place to see the new day. Their motto is America's Day begins here. As the Earth spins, next place we're going to come to that's land is Japan, unless you hit one of the islands along the way. So what Guam does is they look at the clock. At 10:30 p.m., they judge how much they can obligate before midnight. Then what they do is they take the rest, ship it to Japan. Japan does the same thing. If they can still obligate, they set aside what they can obligate. I was with the Marines in Japan, and they were obligating, and they got $10 million from Guam because Guam couldn't obligate the time. So they wanted to use it, but they'd already hit their limit in the law, so they couldn't use any of it. And I've never seen, it's very hard to get tears into a Marine's eyes, but they had tears in their eyes as they let that 10 million go on to Europe, 13 time zones away. Europe goes to East Coast, 6 time zones, East Coast to West Coast, 3 time zones, West Coast to Hawaii, 2 time zones. That's where it usually runs out. Now, I've been told, I've been near it, I think, but never there, that there's an island that we own that sits on the international date line. And I've been told that there's a runway on that island where they used to run, the runway center line's roughly the international date line. DOD used to fly planes in there last day of the fiscal year, land them, so they got 1 more hour after Hawaii. You get off the airplane, the Quonset huts are only on the today side. And even if it's snowing, you can see the Quonset huts. You go in there and you got 1 more hour, at least according to legend. The legend goes on to say that the Navy didn't like paying the Army for the use of that facility, so they had the Corps of Engineers put in place an anchor point for them so they could anchor their ship, or they tie their ship to it. There's an anchor that's got a buoy, you tie your ship to that. And they didn't have to pay, and they could do the same thing. Only then along came GPS, and I'm told, but I haven't seen the evidence to prove it, they had an oops because it was actually on the other side of the international date line, so they quietly moved the anchor point to the right side. I've been told that. Love to know if it's true or not. If you have experience with it, let me know. But it illustrates the point. Time is finite. It stops at a specific point in time in your time zone. You can't use your money beyond that. You've got to leave it alone for obligation. You can still pay your bills under existing contracts, but you can't make any new contracts under it after time runs out. And that's what we're guarding against. How about payment during a subsequent year? So this is what it says in the Red Book. Annual appropriations remain available for an additional 5 fiscal years beyond expiration to adjust and make payments to liquidate liabilities arising from obligations made within the fiscal year for which the funds were appropriated. Incidentally, that 5-year fiscal year expiration period comes from the largest ADA in history, in which people were crushed as a result of it when they thought they were saving the world and may well have saved the world. If you want to hear about it, take my appropriations law class. Payment is not normally a problem at year end, but timing the obligation is key. It's timing the obligation. So what are we talking about? Well, we're talking about when you hit the enter, if you're doing this on your computer, forming the contract, or when you sign it and date time stamp it. And having done this, I've been a contracting officer with an unlimited warrant and temporary head of contracting agency for the Department of Energy. What I would do is I would be doing right down to the moment, and then I'd look up, whoa, too close, shred, right there. Don't sign it, shred it. Don't get too close, because when you date time stamp it, that's it. That's evidence, and you want to be sure you're correct. I also want to point out, when we do this, we're going to come back and look at it. It's not when it's recorded in the accounting records per se, unless you're doing it contemporaneously. It's the signature of the contracting officer that matters. So you'll see your accounting records, sometimes you can't backdate them. So we're going to have to take anything that's happening we can't get into them before midnight. It's going to have the next day's date. So we're not really backdating, but you need to put into the accounting records a note that says this was properly done by this time. See evidence, and refer them to the evidence file. So the purpose limitation. This is what it says about purpose. It's one of the oldest laws on the books, 1809, written because Thomas Jefferson bought something absolutely illegal for him to buy at the time under the Constitution. He did. He bought Louisiana, and he didn't have an appropriation to buy Louisiana. You think he knew what the Constitution said? Yeah, he did. But he was dealing with what he thought was a bigger problem. The British were coming back, and he knew it, and he was right. And they came back, and we had the War of 1812. He's trying to close the Mississippi River and put chains across it, and cannons on each side, so if they came back up to refortify their forts, reinforce their forts, and resupply them and retroop them, then we could blow them up before they got there and keep the fight from going all the way up the Mississippi. That's what he was attempting to do, at least. Then another president came along, didn't fortify, and they came up the Mississippi, and we had the War of 1812. So appropriation for a specific object may be used only for that object. They're applied only to the objects for which they were made, except as otherwise provided by law. But most appropriations are more general. They're not buying specific things. Some are, but most aren't. And they allow us to buy the necessary expenses to achieve the intent of the overall purpose of the appropriation. How do you know what the purpose is? Read the appropriation. It's right there. For operations and maintenance, Department of the Army. For operating expenses, Department of Energy. For salaries and expenses, salaries and expenses, Department of Homeland Security. It'll be right there. You'll see it. But does that allow us to buy necessary expense? Sure it does. It says for salaries and expenses. It's a broad appropriation. So we've got to make sure, though, that those necessary expenses are logical, related expense of that appropriation. That's the key to it. So it's called the necessary expense doctrine. An appropriation made for a specific object is available for expenses necessarily incident to accomplishing that object, unless prohibited by law or otherwise provided for. And so GO goes on to say, appropriations even for broad categories, such as salaries, frequently use the term necessary expenses, meaning the current or running expenses of a miscellaneous character arising out of and direct related to the agency's work. You've got a salaries and expense appropriation. Can you buy supplies? Of course you can, as long as they're related to the agency's work for that purpose. Can you do travel? Of course you can, because it's related to the agency's work. We're not doing a lot of travel these days, but we used to do lots of travel related to our work. We're using things like this instead of travel, which cuts our travel budgets way down. But at the same time, it works pretty well. So there's a test. It's actually 3 tests for necessary expense. First of all, we've got to meet all 3 rules. We must find the logical relationship to the appropriation we're charging of whatever it is we're going to buy. Find that logical relationship, document it. Make sure what you're going to buy is not prohibited by law, because just because you have money doesn't mean you can go buy anything you want. There are lots of things prohibited by law. Those are all articulated in federal appropriations law. Most people don't know that you can't rent space in DC with federal money unless you have specific statutory authority to do so and appropriation to do that. Can't do it. GSA can. You can, for the more than likely. USAID can't. They found out that to their great chagrin. You can't even rent a hotel room in DC for someone else using your purchase card Because when you do, if they don't show, Uncle Sam gets the charge and you have no control over it, and you just violate the ADA. How about that? And most people don't know it. This is why people take appropriations law to learn. Be careful, know what the prohibitions are. There are 13 of them that are hard prohibitions. We don't have time or purpose in this class to talk about them, but you can find them out pretty straightforward if you study it. And then once we are sure it's not prohibited by law, you have to make sure it's not otherwise provided for, not an item that falls within the scope of some other appropriation or statutory funding scheme Congress has come up with. They actually call it a scheme. A scheme is not a negative term, but it has taken on a negative connotation through the years for most Americans. And GO called them statutory funding schemes. Example, organization my daughter worked in got all of its money from DOD. And what DOD would do, because they didn't want to give them that money, is dump all of it on them within 30 minutes of the end of the fiscal year. That's what they would do. And because she had a good team and a well-trained team, they obligated every penny, 20 million bucks as an example, within 30 minutes properly, according to the auditors at least, because the auditors came in and audited and make sure they've done it right. So if you know what you're doing, you can do it right and do it well. Okay, so the expenditure, be careful, make sure that you don't have an appropriation that provides for that particular thing you're going to buy and then go try to buy it with some other appropriation using this rule. It won't work. That's what I'm really stressing here. So to summarize before we go on, what we obligate money for must be a necessary expense of the appropriation we're using, and we must need it when we obligate it and be ready to prove it with documentation, and we must obligate the needs against the appropriation before time runs out. 3 rules to follow, should be pretty easy, but too many people mess up with them. So how about other situations that might be extraordinary? There is some other law that allows us a little more flexibility in certain circumstances. So suppose you really need something and you're at the end of the fiscal year and you can't get it delivered to you before next week or next month, or 6 months from now if it has to be manufactured. So there are special rules for each of these circumstances. We're going to cover each of them in turn. We're going to talk about buying goods and materials, commodity. We're going to talk about buying manufactured or fabricated items. They need to build us an armored automobile. They need to build us a tank. They need to build us an airplane. They need to build us a runway. They need to build us whatever. We're going to talk about services. They could be continuing later. And we're going to also talk about inventory, stock items that we buy for stock to stock up. And we'll explain how you can do that properly at year end on commodity type items. We're going to go through each of these in turn. So here's some key comptroller decisions that have been made that help us out in understanding this. First, the comptroller general has said money is as available on the last day of availability as it is on the first day. When is the first day? It's the day the appropriation has been passed and the fiscal year it's for has started. So both conditions have to be met. The appropriation has been passed and signed into law by the president. It's a law. It's not just an appropriations act by Congress. It hasn't just been enacted. It's got to be signed into law by the president or ignored by the president for 10 days, not including Sundays. Then it becomes law without a signature, or he vetoes it and it's overridden by Congress with 2/3 vote in both houses. In any of those cases, that's when the law becomes law. Okay, so most of them are signed immediately by the president, even though Congress shoves things into them that will really make any president gag because, well, what's their job? Take care of their constituents, and they love to spend money taking care of their constituents. So that's their job. And that's the way they look at it. It's how you get reelected. So sometimes Congress will do things in there that the president looks at and chokes on, but we need the money to do our job, so the president will sign it anyhow. Sometimes the president won't. He'll just let it sit. And those of you who know about, if you ever saw Schoolhouse Rock, they have this thing called a pocket veto. Well, pocket veto only happens when Congress adjourns from session, and they never adjourn from session on something important. But they will pass a lot of trash law. They don't care whether he actually vetoes or not. And then they'll go out of session, and on those the president thinks are improper, he doesn't want to sign, he simply won't sign them, and they'll die because the Constitution says he must return it to the House of Origin, and the House of Origin is not there now. Therefore, he can't return it in that 10-day period of time, and it dies. That's what a pocket veto is. Don't worry about them. They're not going to, it's unlikely they will affect you a great deal. So the timing of delivery is not the primary issue, according to Comptroller General. Instead, it's the need for the items or services ordered. So you always ask, do we need this now? Use now money for now needs. And if we need it now and document it now, I can obligate it now, even though it's not going to be delivered until some future time. So what does that mean for training? I can buy training right up until the last moment of the fiscal year as long as I can prove I need it, and it can be delivered anytime in a reasonable period of time. We'll talk about that a little further when we talk about training as an example. So for future years' needs, they've already said the Comptroller General has an appropriation for a given fiscal year is not available for the needs of a future fiscal year. It was given to you for that year. You can't use it for that other year. But an appropriation is as much available to supply the needs of the last day of a particular year as any other day or time on the year, or the last minute for that matter, or the last second. As long as you stay the right side of that clock, actually depends on how you measure time. As long as you stay inside the timer, you're okay. Outside the timer, the whistle gets blown, you get in trouble. The timing of the obligation does not in and of itself establish anything improper. It doesn't, because when you look at the recording of the obligation in the accounting records, it may be recorded after the obligation is actually made. So what we do is we go back and look at the actual document and see when the document is actually signed. So a general rule, the agency can obligate its funds when it is apparent from the outset there will be no requirement until the following fiscal year. There are 3 specific exceptions under this, and they're found at page 5-22. Materials are unavailable. We need production or fabrication time, or the vendor does, and we're replacing stock. Let's cover them each. Here's what it says on materials. Where the materials cannot be obtained in the same fiscal year in which they are needed and contracted for, provisions for the delivery in the subsequent year do not violate the bona fide needs rule as long as the time intervening between contracting and delivery is not excessive, underlined by me. And the procurement is not for standard commercial items readily available from other sources. So this is not for buying oil, gas. It's not for buying paper and pencils. But when it's something that you can't get the materials in time before the fiscal year ends, so long as the time to get it is not excessive, you can order it now. What does excessive mean? Generally, it's interpreted as meaning more than 120 days under law. Generally, that's what it would mean. Most of us consider it to be 90 days under law. So what we do is we do buy these and expect delivery within 90 days. 120 days for me would be excessive. That's my view. But I think in many cases, they've interpreted it to be up to 120 days. 90 days, is where I would set the standard myself. You set it for yourself. Be sure you check your agency's standards because they may have set it differently. So we've got the ability to do it. We can do it so long as we get it within 90 days. That's a 1959 decision, by the way. It's been around a long time. An agency may contract in one fiscal year for delivery in a subsequent year if the material contracted for will not be obtainable on the open market at the time needed for use, provided the intervening period is necessary for production of fabrication material. So if it's not available and you're near the year end, but it is there and can be quickly available, make sure that it's delivered to you within a reasonable period of time. I would say 90 days myself. On the other hand, if it's simply not obtainable at all, and it takes time to produce it or fabricate it by the vendor, then there's no limitation on how long it takes to produce it or fabricate it specifically. I wouldn't want it to run 3 years. I wouldn't want it to run even a year. But if it's something we really need now, we're going to obligate for it now, and they're going to deliver it to us as soon as they can. Example, the most delicate instrument on a submarine is the propeller. They're gigantic things made of solid bronze. They're one of the most beautiful things you'll ever see outside a museum because they're perfect. They're machined to within 1/100,000th of an inch. All those blades are. It takes 3.5 years to make one of those propellers. It only takes about 2 years to build a submarine if you're working expeditiously on it. So what we do is we order propellers well ahead of time to go on our submarines that we're not going to start to some future time, because the only way we can get them is to order them now, because they're made from a single block of bronze that has to be cooked until it boils. And then we have to cool it very slowly to all the bubbles come out of it. Then we have to machine it until it's perfectly smooth, because when that thing goes in the water and starts to turn, if there's an imperfection in that blade, it creates a little vacuum as it goes through the water. Oxygen comes out of condensation, goes there, and when it comes away in a little bubble, it goes crack, snapple, and pop, and it's crack, snapple, and pop. Yeah, I think that's it. Like your Rice Krispies, and that's exactly what a submarine sounds like 5,000 miles away. And we can find it and shoot it. We can, and they can. That's why these are the most delicate instruments you'll see outside of satellites that we produce for the federal government. So on this case, we have to order them well ahead of time. We're going to order them. What if the submarine gets canceled? Well, we got an extra propeller sitting there that hopefully will fit the next submarine. So that's one example. And that example goes back to 57, because that's specifically why they went after this particular issue. Now, how about stock and inventory? Well, we do have a replacement principle available to us, but look at the bottom caution. Administratively approved stock levels are required in advance. So if you have to restock, then an order or contract for replacement of stock, readily available common use items, is viewed as meeting a bona fide need of the year in which the contract is made, as long as it's intended to replace stock used in that year, even though the replacement items will not be used until the following year. This is a long-standing decision, 1965. Actually, that's a long time ago. That's when I entered college, actually, in 1965. Incidentally, we've only had 3 years of surplus in which our government brought in more money than we paid out since 1969, 4 years after that. 55 years of creating debt, which is why we've got the debt problem we're dealing with. So that's in chapter 5 of the Red Book in the 3rd edition. But I want to emphasize once again, administratively approved stock levels are required in advance. How do you do it? Study what you need, determine what you need to carry you forward for some reasonable period of time. I would say 90 days. And then I would say, in order to carry us forward for 90 days, if that stock is no longer available in the open market, as it wasn't during COVID, to remind you, for much of the stuff that we buy. So I've got this set up. I've administratively approved it. That's not me. I'm going to take it a level above me, maybe 2 levels above me, get them to approve it. Maybe head of contracting agency might be a good one to approve it. And once they sign that, then I'm going to stock up. And what I'm going to do is, as I approach year end, I'm going to buy up to that stock level and keep it there. As we go past the year end and enter into a continuing resolution, because Congress didn't do one of its 3 jobs. Their 3 jobs are pay the national debt, provide for the general welfare, and provide for the national defense. That's their 3 real jobs under the Constitution. So, well, they didn't do their job. I'm going to stock up when they do give me the continuing resolution. I'll be burning down at the moment that's about to end. If I've got cash, stock up. When the next continuing resolution comes in, I'm going to stock up, keep that stock level there, maintain it all the way through. When we get the next continuing resolution, we could have 23 of them, which we did in 1 year way back. I'm going to keep stocking up to make sure that you have fuel to use, which is what Defense Logistics Agency provides for the entire government, as an example. See how important this could really be. We don't have any fuel. When I was in Vietnam, we had 7 days of aviation fuel supply available in the Pacific Fleet. We were 7 days away from shutting down all of our airplanes because we had no aviation fuel. Because of this, we didn't have this principle at the time. 1965. Actually, I wasn't quite to Vietnam by then, but that's why they wrote it, because we had that kind of problem. It occurred again because they didn't buy it. Someone didn't buy it because they were afraid to buy it and didn't know the rules in 1960, 1970. That's when I was there first. Okay, so be sure you do in advance the administratively approved stock level. Now, services are somewhat different matter, because ordering of services at year end depends upon the severability of the service. What does that mean? Well, is that service continuing and delivering similar or the same products over and over again to us, or services over and over again to us? So window washing is purely severable. We can sever at any time, and all we lose is the future benefit of that contract. Building a ship ain't severable, because if you stop building the ship, you got that rusting hulk in the backyard to get rid of, you got all those employees to lay off, and you got that shipyard to shut down. That's not a severable contract. So if it's a non-severable service, such as auditing, if you stop the audit, you don't get the audit report. If it's bridge building, if you stop building the bridge doesn't get finished. So those sorts of services are non-severable. They are allowed to extend beyond the end of the fiscal year if you use the right authority. So let's talk about 4 services in particular, 5 actually. Training, services provided by you, federal employees, or other agencies to you. Services procured that can't be severed, cannot, and services procured that can be severed. And we'll talk about interagency agreements at the end of it. So first of all, the authority for training for government employees is governed by the Government Employees Training Act at 5 U.S. Code Chapter 41. It's broad. And GEO's already said long ago, training tends to be non-severable. Thus, where training obligations occurred in one fiscal year, the entire cost is charged with that year, regardless of when the training is actually delivered, due to the scheduling of the training organization, not the government. You can't say, well, I'm 3 months before the end of the fiscal year, we'll just use up some money now for next year, obligating it now, even though we could do our own training internally right now. Can't do that. It's got to be unavailable in order for us to go beyond the fiscal period. And if you're at the end of it, of course, any training is unavailable right then, that day. So what you do is we can use that even for intergovernmental training when we're very near the end of the year, but I wouldn't before. So where it's incurred in one fiscal year, the entire cost is charged that year if it's non-severable. Example, I had the privilege and the benefit of attending the advanced management program of the Harvard Business School, their top executive management program, courtesy of the government. And because they could not deliver it to us quickly, it was only schedulable in advance. And because the boss decided you need to know more about how senior people think strategically in executive roles around the world, and you need to do this. So they were able to send it to me, even though it wasn't delivered until the next summer and the summer after that, using this particular principle right here. In essence, if the training is legitimate and the agency has a need for the training, training becomes a necessary expense of the year and is obligated, so long as it's not immediately available to us. Then it's a necessary expense, even if it goes beyond the end of the fiscal year. Now, let's talk about several services contracts. Different situation. Where the services are continuing and recurring in nature, the contract is severable, as I've already said. Service contracts that are severable may not cross fiscal year lines unless authorized by statute. 71 Cont. Gen. 428, 1992. But most federal agencies have authority now, cited at Principles of Federal Appropriation Law, page 5-25, to enter into one-year several services contracts beginning at any time during the fiscal year and extending into the next fiscal year, and to obligate the total amount of the contract to the appropriation current at the time the agency entered into the contract. And these citations are all wrong in the Red Book. These are the correct citations here. If you're in the executive branch agencies, it's 41 U.S. Code 3902. If you're legislative branch, 41 U.S. Code 3904. And if you're in DOD, it's 10 U.S. Code 3133, and it includes leases for DOD specifically. Okay, so there's the rule for several services contracts, and there are the exceptions to the rule. And so there's a major exception that allows us to do longer contracts for several services, not for our own people, though. We'll come back to that. Services provided by agency employees, and here we are chargeable to the fiscal year in which the services are rendered, regardless of whether the services are severable or non-severable. So if you are working on a service, your time runs out on the money, you're going to stop and be sent home. As I've been sent home, and some of you have been sent home, I've been sent home a whole bunch of times. And if you're a Fed, thank you, Congress, for modifying in 2015 the Anti-Deficiency Act, you're covered because you're going to be paid as soon as we have money to pay you when you come back for your time off. You will. If you're an emergency essential, sorry, you're going to be working, you don't get the free vacation, but you're going to be paid as soon as we have money to pay you once that appropriation is passed. So how about another agency's employees doing work for us? Same principle applies to them unless, I repeat, when an agency's employees are doing work for us, or we are doing work for another agency with our own employees, this same principle applies unless we've taken precaution to set the contract up, the interagency agreement up differently. So we have a special rule for that. So under the authority at 41 U.S. Code 3902, 41 U.S. Code 3902, 41 U.S. Code 3904, and 10 U.S. Code 3133, as you already know, we can enter into one-year civil services contracts. And for the first time in history, in 2015, GAO finally admitted that even though legally the government can't do a contract with itself because you can't do contracts between the same party, it's got to be two separate persons. These interagency agreements are, quote, akin to contracts. Therefore, we can use that principle and we can, in fact, allow other agencies' employees to do work for us beyond the end of the fiscal year. And we can allow our own employees to do work for them beyond the end of the fiscal year. Now, be careful. The auditors will be looking for you giving them your job and them giving you their job to do. That's not what we're talking about. We're talking about doing legitimate work for others. But we can use this principle if we cite the appropriate authority, which is 41 U.S. Code 3902 for most of you. If you're in legislative, 41 U.S. Code 3904. And if you're in DOD, use 10 U.S. Code 3133. Do not cite the Economy Act. If you cite the Economy Act, it all falls apart. You can't do that. You got to stop everybody working at the end of the fiscal year if they're federal employees. Okay, so here's the statute. Here's the decision by GAO. It's B323940. Be sure you put the dash in or you won't be able to find it when you search it on the GAO website, but you can use that number and go right to it. And here's what it says. The U.S. Army Europe may enter into a one-year contract for several services that begins in one fiscal year and ends in the next fiscal year under statutory authority in 10 U.S. Code 2410, now 10 U.S. Code 3133. U.S. Army Europe may also rely on this authority to enter into interagency agreements with GSA. An interagency agreement is akin to a contract, and the obligational consequences of an interagency agreement entered into under our GSA's revolving fund authority are the same as if it were a contract. Therefore, we can do the same thing. That's a magic clause there, or magic decision there, that allows us to do more with our money at year end if you need it. If you need work from others, other agencies, this is for contracts, and it's also for other agencies now. Do the interagency agreement correctly, cite the authority we've cited here, and you're okay. It's magic. Okay, now, I cannot imagine why anyone would still be doing one-year interagency agreements that end at the end of the fiscal year. It's dumb. I just said, that's an opinion. I said I wouldn't express opinions. Sorry, that one escaped my lips. It's dumb. Why? Correct them so they go mid-year, and now you can keep the work that's being done for your agency by another agency going because you just took the effort to create it right. Many people have now absorbed this, but a lot of them haven't. So contracts by the entirety. A contract viewed as entire is chargeable the fiscal year in which it was made, notwithstanding performance may have extended into the following fiscal year. As I said, the training is usually considered a contract by the entirety. Not a series of training courses, but individual training courses are in and of themselves contracts by entirety. So an Economy Act order is typically not considered a contract by the entirety. They remind us of that in the Red Book. How about multi-year contracting? So let's talk about the prior authority and then some update to that. An agency may engage in multi-year contracting only if it has no-year funds or multiple-year funds covering the entire term of the contract or specific statutory authority Congress gives you separately. But if you do have this fiscal year appropriation issue and you don't have multi-year contracting authority, the only thing you can do to get multi-year action planned and readily in place is to either do separate fiscal year contracts or do a single fiscal year contract with up to 4 renewal options, with each renewal option first contingent on the availability of future appropriations, and second to be exercised only by affirmative action on the part of the government. So we actually don't have contracts in those options. Those are really not contracts until they're signed by the contracting officer. So be careful with this. You could still end up left out with them unable to do the work on a contract or an interagency agreement using this authority. Instead, use another authority. Most agencies now have 5-year, multi-year contracting authority from annual funds. We do. All executive branch agencies authority are found at 41 U.S. Code 3903. which allows multi-year contracts for acquisition of property or services for more than one, but not more than 5 years. There's a problem with it in funding it. I'll come back to it. You've got to be careful. 41 U.S. Code 3904 extends this to most legislative branch agencies, but administrative determinations are necessary. We'll talk about those in just a moment. Incidentally, the ones they refer to in the Red Book currently, the DoD, NASA, and Coast Guard specific statutes, were repealed when they put in place 41 U.S. Code 3903 and treated us all in the executive branch alike. So the right reference is 41 U.S. Code 3903. Can we use that for interagency agreements? Sure, using the same principle. Interagency agreements are akin to contracts. Therefore, we can use the same principle for interagency agreements. In order to do it, though, you've got to make some administrative determinations. First, funds are available now, and they're obligated for the full period or the first year plus estimated termination costs have to be obligated because it protects us. If we don't get new money, we can simply terminate the contract, pay out the cost as liquidated damages, and walk away. The bona fide need must also exist and must be reasonably firm, continuing over the full contract period. And we have to determine the multi-year contract is in the best interest of the federal government by encouraging full and open competition or by promoting economy and administration performance and operation of agencies' programs. As for me, if I'm auditing you, I want to see that you're saving substantial money for the government by doing it this way. That's what I want to see. And let me tell you, those contractors will line up to get these. They will line up for them. Why? Well, it costs a lot of money to bid on your contracts. And we lose a lot. We do. So they'll line up for them. They will. Interagency agreements, same way. So now that we've covered those, let me just mention some specific agency or item authorities. 10 U.S. Code 2828 allows leasing family housing in foreign countries by DoD for up to 10 years and up to 15 years in Korea. We plan to be there a while. Telephone and other utility charges under 31 U.S. Code 1308, you can charge the bill to the ending fiscal year. So they don't try to follow our fiscal year in those telephone and utility companies. They follow their own fiscal year and bill you when they want to bill you. So you get one in for the cost, you get one in January for the cost of the last half of December and the first, well, let me see, I'm saying that wrong. This doesn't affect us because it doesn't matter. We get mid-year, mid-month billing, and in January, December, it doesn't matter. It does matter in September, October. So this allows us to pay the September, October bill from either account. And that's a pretty handy little thing to have available to us. But be sure that you do have the money to pay when you do pay. On GSA leases, 40 U.S. Code 585 lets GSA lease for periods up to 20 years. One other point that is not law, it's simply an opinion. One of the dumbest things we do is lease buildings over and over again for periods of 20 years. Why? You can buy the building and own it, and you don't have to lease it and keep paying for it. But those leases make some constituents really, really rich, and Congress loves long-term leases. Doesn't make sense. Commercial leases are structured to pay for the building in 7 years. How do I know? Well, I worked in industry. I've looked at these leases. They're going to pay out sometime soon, and you're going to keep paying and paying and paying and paying. Okay, so finally, that's just an opinion. Look at them closely. Be sure we're not putting ourselves into a bind when we're doing these long-term leases that we probably don't really need because they may get terminated because we don't have money to pay for them later on. If we own the building, we got the building. We have to maintain it. We have to take care of it. Okay, so check your agency's regs for other extraordinary statutory authorities that you might have. Some of your agencies have unique ones. DOE, as an example, has some very unique authorities. State Department has some unique authorities. Be sure and check those beyond what we've talked about here. And if your agency decides to write a regulation saying you can't use one of these authorities, you can bet they probably have the authority to do it. So double check, make sure there's no prohibition by your agency, and here you go. Now you can use your money properly. Let's talk just for a minute, about a minute total is all we have, about grants and cooperative agreements. So they're different. We've been talking about contracts, purchase cards, and all those, which are contractual agreements. But with a grant and a cooperative agreement, they're different. The bona fide needs rule applies to all federal government activities carried out with appropriated funds, according to GAO. However, they go on to say, the agency's need is to make the grant when you have grant authority. Therefore, the grantee's use of grant funds has no relevance in the assessment of your needs. You simply have to need the grant. You can make the grant. You need to make the grant. Why? They gave you the money to make the grant this year. You need to make the grant. So make the grant. Just make sure you monitor them carefully, because lots of people have gotten into a lot of trouble because the grantees have not been diligent in their execution of the grants. The bona fide needs analysis in the grant context focuses on whether the grant was made during the period of availability of the appropriation charged and furthers the authorized purpose of the grant legislation. Put that there so that if the auditor bugs you about it, you can give them the quotation, tell them go back and read it. They should have read it anyhow, because this is a major topic, the appropriations law and training of auditors. It's a major topic. They study appropriations law, and they all should know it. But just in case they don't, there's your citation. So putting it all together, two cases: buy supplies at year end, buying training at year end, services. So we ask and we document, are the supplies to be ordered necessary to the purpose of the appropriation being obligated? If yes, then go on. Does the need exist now, and will it continue to exist? If yes, go on. If the answer is yes and documented, then you can order up to 5-year supplies under the multi-year contracting authority, obligating all of it from this year's appropriations. Or alternatively, you can order up to 5-year supplies under the multi-year authority, obligating this year's authority for the initial funding plus the termination costs. So you can simply cancel the contract, pay it out if they don't appropriate the money for the next year. You have to give special notice to the contractor. It's in the FAR. The contract is void if follow-on appropriation is not made available by Congress. But they will line up to compete on these, even though they may have no money coming from it. They will, because likely that Congress will appropriate the money in most years, and you'll be able to continue on. Now, buying training, ask and document the following items. Is this training necessary to our agency and the appropriation being charged? If so, go on. Does this need exist right now? If so, go on. If the answer to both is yes and documented, then training is generally non-severable and may be obligated using currently available funds like other non-severable services. In April 21, and the reason I'm putting this in here at the last minute and taking a couple more minutes of time, because I want to leave a few minutes to look at questions and answer them. In April 21, GEO did something interesting, because the problem that has been going on for many, many years, actually since the ADA was put in place, is up to this point in time today, no Attorney General of the United States has ever prosecuted an ADA violation, even though it's been recommended by numerous agencies. It's never been prosecuted. So we also have some problems with the Impoundment Control Act, as you're learning right now. Its problem is there's no enforcement mechanism. The only thing GEO can do is sue the executive branch in federal court to comply. So GEO recommended to Congress that they said to them very bluntly, your ADA thing that you consider the cornerstone of control over the executive branch is not working. It hasn't worked ever very well. People get fired, sure. No one's ever been prosecuted. And secondly, the Impoundment Control Act isn't working because it has no enforcement mechanism, in part, but they explain other things wrong with it. So what are they doing? They're suggesting to Congress strongly, 4 years ago, that Congress fix them. And Congress has been looking at how to fix them ever since to make them stronger. So what am I telling you? Be careful. Increased surveillance and improved enforcement are very likely in the future. In whatever Congress decides to do, you got to make sure that you stay well within it. Okay? I don't want to tell you they've never prosecuted the ADA, and you say, okay, well, I'm going to ignore it. No, we're going to fire you. We can do that, and there's no reclamo. Violate it seriously, you'll get fired, and there's no appeal. GEO said the Supreme Court said long ago, there is no appeal. The law is clear. The agency can fire you outright if you violate it, so don't violate it. And be careful, because we don't really know how the Impoundment Control Act affects YOU. We don't. We do know that Congress can impeach a president over it if they choose to do so. But you know how those typically work out. So that's all we know about them right now. But there's a lot of attention being paid by the press and everyone else to it right now. Don't be the goat. Stay within the bounds, do it right, and do your job right. You're okay. And that's what we want, and we're glad to help you. So, like Davy Crockett said when he was a congressman of the United States, one of my favorite boyhood heroes, because I'm originally from Tennessee and so was he. It's the only thing we really have in common, except for this. Be sure you're right, then go ahead. Make sure you're right, then go ahead. We're here to help you stay ahead of developments and current with changes in your authority and responsibility. And on this matter, that's all I have to present today. So we'll take a look at questions if we have some. Shige, who's the very best producer I've ever worked with, Shige Takshita, is with us today. And if you'd say hello, Shige, and tell me what we've got that needs to be done, I'll be glad to answer any questions we can.
Steve, I am not seeing any questions in the chat just yet, so that may be may explain some of Shige's silence. I guess we'll keep watching.
Okay.
But I will, while people are maybe typing those questions in QA or chat, if they have any, I know we do only have a couple of minutes left, but I'm going to drop in our chat. A few times throughout the presentation, Steve mentioned that, we have some classes that can help with this. He referenced the appropriations law class a few times, and boy, is my heart hurting for that $10 million that you mentioned earlier in the presentation. Let's not let that happen to folks here. So I'm going to drop in a bunch of links. The first one is going to be to all of our financial management classes in case there's, maybe it doesn't have anything to do with this webinar necessarily. A lot of great links in there. But then I will drop some links specifically to some of the classes that Stephen mentioned throughout the presentation. And if you don't grab them right now, you got to run to another meeting or whatever, no worries. When we send out the recording of this webinar or a link to it, it'll be in that email. So all that'll be right there with you.
As you're doing this, I also want to thank each of you for joining us today. It's a delight to have you with us. We do truly appreciate you, our customers and clients and friends, and we do want to hear what's going on. We do want to help with what's going on, and just let us know how we can help. It's an important thing that we're going through right now across the entire government. The end of year happens every year, but these major changes in policy and process don't happen that often, as it changes, as things modify, we're going to be modifying whatever we're delivering to you to comply with whatever the new decisions are by the new Congress and by the president. And we'll try to make sure we keep you abreast of it as best we can. We try to do these a couple of times at the end of the year each year. So tune in when you get a chance. We're glad to have you here. And let other people know if you think they'll be interested in it. We're going to do another one coming up in August. I think it's on August 8th. We'll do a live one as well. And if you want to join us for that, you're welcome to, or you know someone who might benefit from it, let them know. Because truly, in this particular case, it's a good group of people at graduate school trying to help you in your business and help you stay away from problems. And not including myself, because I'm essentially a part-timer with the graduate school. They've got a good staff there dedicated to make sure that they provide quality products to you and make sure that we can do everything we can to help you do your job.
Thank you very much, Stephen. Yeah, I went ahead and dropped all of those links in the QA area. Hopefully you can all see that. And Stephen's absolutely right. Yep, August 8th for any colleagues that you might have that weren't able to join us today. And yes, thank you all very, very much for attending. I haven't seen any new questions come in, so why don't we does that sound good, Stephen? We could give folks a couple minutes to get ready for their next meeting.
Yeah, sure. This is the first time we've actually finished a little bit ahead of schedule because we have had questions. So that's actually good for you and good for them, probably, because I know everyone's busy this afternoon. So I wish you all the best, good luck, and let us know how we can help.
Thanks, everybody. Thanks for all the reactions down there, too. Thanks a lot. Have a great rest of your day. Bye.